Alice and I are always looking to be more healthy, and we were just talking about how fasting is one of the best ways to do that, but it's so hard. But the great thing about Prolon is that's not what you're doing. It's not that you're not eating for 5 days. Instead, you're using their science-backed program to convince your body you're fasting.
You guys, this 5-day program really is amazing. It comes beautifully packaged and it does all the thinking for you. Each day is its own box. And by following their program, I know I just feel so much better. And I can't wait to experience Prolong Next Gen and continue to see results. For a limited time, you can be first in line to experience the new Next Gen at special savings. Prolong is offering the Prosecutors listeners 15% off site-wide plus a $40 bonus gift when you subscribe to their 5-day program. Just visit prolonlife.com/prosecutors. That's PROLONLIFE.com/prosecutors to claim your 15% discount and your bonus gift. prolonlife.com/prosecutors.
I'm Brett.
And I'm Alice.
And we are the Prosecutors. Today on the Prosecutors, we discuss the closing arguments in the Chauvin trial, the intricacies of the jury's verdict, and what the sentence might be. Hello, everyone, and welcome to this episode of The Prosecutors. I'm Brett, and I'm joined, as always, with my collegial co-host, Alice.
Thank you, Brett. I think it may have been more appropriate if you said, crawling back into the closet, quite literally. I know last time we tried my laundry room, but the sound is just so good in a closet, so I'm back in a closet in a new house.
Alice is sacrificing comfort for the quality, sound quality, because I'm not a good enough audio engineer to deal with those issues. So thank you, Alice, for all the sacrifices you make on behalf of the audience.
Anything for our audience, but thank you guys for just hanging with us as we figure out sound in new places.
And thank you all for sticking with us in this quasi-live coverage we've done of the Chauvin trial. I know the verdict's been in for about a week now for about a week now when you hear this episode. I will point out, if you were a patron on our Patreon, you would have received all of the episodes except for this one before the verdict was read. So just a little shout out for the Patreon if you guys want to become patrons. In any event, we've reached the end of this trial. By now you know the verdict. Derek Chauvin was found guilty of all 3 counts that he was charged with in the murder of George Floyd. We're going to get to that in a minute and sort of talk through a lot of the legal questions a lot of you have asked us about that about that conviction and what it means for a possible sentence. But before we do that, we do want to take a moment to walk through the closing arguments. We've been at this from the beginning. We started with the openings, and we did not want to skip the closing arguments, even if you already know what the verdict is going to be. And I think when you listen to these closing arguments and some of the points that the prosecution and the defense made, some of you who had some questions about how the jury came to the conclusion it came to, or whether the jury came to the correct conclusion, I think these arguments really do exactly what they're supposed to, which is lay out the law, lay out the facts that have been established at trial, and tell the jury why they should reach the verdict that the various parties want them to reach. And we'll start, as every case starts, with the prosecution. The way that argument works is the prosecution has the first word and the last word. And the reason for that is the burden is on the prosecution. We all know this, that the prosecution must prove that the defendant is guilty beyond a reasonable doubt. There's no burden on the defendant. The defendant doesn't have to say anything. If the defendant doesn't want to make an opening statement or a closing argument, they don't even have to do that. They can sit silent. The prosecution has the burden. So the prosecution starts, then the defense makes its argument, and the prosecution has an opportunity to rebut the things that are said. And in this case, the prosecution began in what I thought was a very powerful way with a sentence. His name was George Perry Floyd Jr. When I was listening to this argument, this immediately struck me as incredibly powerful in a very simple way. It spoke to Floyd's humanity while also subtly tipping the prosecution's cap to the movement that had erupted after his death, which often resolved itself into a very simple demand that people, quote, say his name. I'm sure you've all heard that, and the prosecution tapped into that, something everyone would have understood in the courtroom without making it explicit. And the prosecution didn't just drop it there. They spent some time at the beginning of this argument not talking about that day in May or what happened to George Floyd, but talking about the person that he was, introducing Floyd and his life and his family. And then after they did that, that's when they returned to the theme that they had laid out in their opening statement, that symbol, that second symbol that was so powerful, 9 minutes and 29 seconds. And the prosecution talked about the struggle of Floyd's to breathe. They talked about how, with his last words, he asked for help. Please, I can't breathe. The prosecution pointed out that Chauvin had to have known how bad things had gotten for Floyd. He was on top of him. They reiterated how many people called the police on the police, and they noted that even the children in the crowd, even the 9-year-old, recognized what was happening.
And the prosecution reiterated that this was not a prosecution of the police and that the police were on the side of the state. They went through the witnesses who said, "We do not train this kind of behavior." And then the prosecution said, "You heard the defense in opening argument say that Chauvin followed the rules. Chauvin did not follow the training, did not follow the use of force rules, did not follow the duty to render aid. He betrayed the badge. This is not an anti-police prosecution. It's a pro-police prosecution." The prosecution noted that his was a power trip, a pride trip. He wasn't going to let that crowd tell him what to do. He wasn't going to lose. Chauvin wanted to win, and Floyd paid for it with his life.
And this is something we had talked about just as we were listening to testimony, that the prosecution wanted to make clear this was not about the police. They were separating themselves from a lot of the bigger picture things that people have talked about, because at the end of the day, this trial is really not about the police. It's about one incident between two people. And the prosecution wanted the jury to know we're on the side of the police, and the police are on our side too. And they talked about this thing that Alice and I both pointed out in the last episode, that it really seemed like for Chauvin, this was as much about the crowd as it was anything, and not his fear of the crowd, his wanting to project that he was in charge, and he was not going to give in to those people. He was going to win, and they were going to lose. And the prosecution also stated something that I think has resonated with people across the country and was always a danger in the strategy that the defense pursued, and that's that Floyd was not on trial here. Now, we've talked about why it was important, what happened. We've talked about how all the factors matter. You know, it's interesting. We used as an example, I think in the last episode, a shooting that happened in Knoxville, Tennessee. And at the time we recorded, that seemed very straightforward. It seemed like you had a school shooter who actually shot a police officer, and the police were forced to shoot that person. And we talked about how you've got to know all the facts before you can make any kind of judgment. Well, interestingly, since we did that, we actually have learned new facts, which have put a different spin on that. It seems like the police officer in question wasn't shot by the kid, but was actually shot by another police officer. And so that is still a developing situation. But it serves to reiterate that you can't make these decisions without knowing all the facts. But while that's important, it doesn't change the very important fact that George Floyd is not on trial. And the prosecution did a very effective job of noting that within seconds of the event beginning, an officer had already pulled his gun on Floyd without really any resistance from Floyd, and used a very early camera shot from one of the body cameras, one that's not famous, but I think has become famous since the prosecution used it, of the gun in Floyd's face and the fear on his face. The prosecution stressed that Floyd initially complied, and they went through his compliance at the beginning of the interaction, how he sat on the curb, how he told them his name, how he was completely compliant and only started to resist at the point where the police tried to put him in the back of a vehicle. Now, I didn't love this part of the prosecution argument. They had not really contested this part, the resistance part, while putting on their evidence, and now they were kind of trying to say that Floyd was refusing to get back in the car for all sorts of various reasons. But at the end of the day, he did refuse to get into the back of the car, and it's not as if they can, it's not as if they're excusing what he's doing. So I don't know why they spent so much time on that. And I think it's better to talk about how the police responded to that resistance, and they do move on to that. And then they say something that I thought was great. They talk about how when you're deciding this case and you're thinking about reasonable doubt, that common sense comes into play. When the defense is making an argument to you, one of the things you have to decide is that argument, does it make common sense? And one of the prosecutors said, when discussing the theory that Floyd died of an overdose, that's, quote, not common sense, it's nonsense.
And the prosecution then walked through the crime and the elements as well as the charge from the judge. Now, this is a good thing and a very common thing to do. The prosecution is going to tell the jury what the charge says, and then the judge is going to read the charge. And that actually gives the prosecution some credibility, because when the jury hears this charge from the judge, they're thinking, oh, the judge is the neutral figure who has power in this courtroom, and he's saying what I just heard the prosecution say, then lending credibility to everything the prosecution has said. That's a pretty common thing for the prosecution to do. And though so far we've heard a lot of storytelling, a lot of emotion, a lot of presenting who George Floyd is, the purpose of a closing argument is actually to walk through the charge that's been brought and the elements and why the facts brought during trial meet the elements of the crime that the prosecution is trying to prove. And so here the prosecution gets to it. They get to the crime and they talk about the elements with the jurors. Now, the prosecution points out that if the defendant primarily caused the death, it does not matter if there are some secondary causes of death as well. Obviously, this has been the defense's story throughout trial, that it was the drugs that may have contributed to the death, not just Chauvin's knee on George Floyd. The prosecution used a chart with the various charges and laid out what the jury needed to find Chauvin guilty. The prosecution did an excellent job of laying all this out, because remember, there are 3 charges before them and they have different elements. So to be able to lay it out visually is helpful for the jurors, because they quite literally have to check through all of the elements before determining if the prosecution has met its burden. So by visualizing this for the jurors, the prosecution is hoping to do the work for the jurors, so when they get back to deliberations, they think, well, the lawyers have already done the homework for me. I know all the elements have been met because I saw it visually during closing arguments.
Yeah, I thought the prosecution's closing argument was really good. I thought it was the perfect balance of passion and emotion, and also the dry technical stuff. That's actually the most important thing for a jury that has to make these kind of decisions, and that's sort of what they ended with And their initial argument was this chart, it was like an interactive chart, and they just went through every element of each charge and how the evidence had proven that element. And by the time they finished, I was thinking the defense has a pretty steep hill to climb. Now, I'll say this. I thought the defense closing was pretty good. I thought the defense closing was probably as good as it could be. And they started with the definition of reasonable doubt, which, as I said earlier, I don't always love that, but I thought probably in this case that was the most important thing for them to hammer on. But the defense attorney, in contrast to what I heard in his opening, this wasn't a dry recitation of what reasonable doubt is. This was a much more passionate statement, a passionate argument that implored the jury to apply the standard, to set aside everything else and just look to whether or not there was doubt in this case and whether or not the prosecution had proven its case. The defense used an example of making cookies. You got to have all the ingredients or the cookies won't work. If you're missing anything, the cookies fail. Same for these crimes. You must prove all the elements or you lose. Now, there were a lot of biased commentary on this, on both sides. And there were some commentators who criticized this analogy, but this is pretty standard fare for defense attorneys. Every defense attorney has their little shtick about what reasonable doubt is. I've heard one attorney say that the cases are like pancakes, and no matter how thin the pancake, there's always two sides. It's always little things like that to endear themselves to the jury. Now, the defense goes through what the officers would know at the time. So as the officers are arriving on the scene, what would they know from the 911 call? They would know a business is requesting help following a crime. They would know the suspect is still there. They know he's a big guy, 6'3" or so. They know he's on drugs. Now, Chauvin is actually not one of the first officers to arrive. Other officers arrive. And Chauvin actually receives a top priority call to go to the scene and assist these officers who were involved in some sort of struggle. And this would have put Chauvin, the defense says, on heightened alert and concern when he's arriving on the scene. Now, the defense argument is far more grounded on the reasonable officer standard. The defense really, while the prosecution walked through the elements of the crime, the defense walks through the law on reasonable officer. The prosecution had basically said, believe your eyes. They said that several times. You've seen this. Believe your eyes. That's not a reasonable argument. And it's an interesting question which approach is better. On the one hand, the defense argument is a little dry at this part, and it is legalistic, and it is detailed. On the other hand, it does a pretty good job at demonstrating that this is a very complicated analysis for an officer to make, and a more complicated analysis than perhaps we see on tape, and one that they're having to do in real time under real-world stresses, not in the comfort of a courtroom. The defense very much focuses on the early portion of what was happening, while the prosecution focuses on the last parts of the encounter. The defense hammers on how the 929, quote, ignores the prior 16 minutes and 59 seconds. The defense also points out that there was no physical evidence of asphyxia. You may recall this was one of the last things the defense put on with their expert. But everyone agrees. Every expert who talked about this agreed that Floyd's heart was enlarged, that his arteries were blocked, that his fentanyl level was high, that meth was present, and that all these things were found by the state's own doctor. This is the defense going back to that weakness we recognized at the very beginning. Dr. Baker, the state's own doctor, who said some things which made the prosecution's job a little bit more difficult.
Now, you may remember that Jerry Blackwell gave the opening statement in this case. And as is pretty common, you split up the closing arguments. There's an opening close for the prosecution, and then there's the rebuttal close. The rebuttal close is really where you bring the fire. It's much more on your feet. You have already gone through the elements in your opening close. The rebuttal close addresses the defense's closing argument. That's where you come in with like the rage of justice. And Jerry Blackwell gets up on rebuttal and he said, "It was so simple. a 9-year-old girl understood. Why is it necessary to continue to apply deadly restraint to a man who is defenseless, who is handcuffed, who is not resisting, who is not breathing, who doesn't have a pulse, and to go on doing that for another 3+ minutes? How is that a reasonable exercise of a use of force? You can believe your eyes. Now, the prosecution noted that the whole discussion from the defense cut off before the last 3 or so minutes of the incident. The prosecution ends by saying that George Floyd did not die because his heart was too big. He died because Chauvin's heart was too small.
And I think, as is often the case, the rebuttal closing here really, it lays out the prosecution's strongest point, and I think it's the reason the prosecution wins. The reason that Chauvin is ultimately convicted, remember, all of these charges are unintentional murder. No one on the prosecution side is saying that Chauvin set out to kill Floyd. So they must prove that at some point, Chauvin was doing something that was so unreasonable that it transformed legal action into illegal action. And you can't get past those last 3 minutes. I don't care. I don't care what else happened. I don't care what else was happening with Floyd. You know, imagine a situation in which Chauvin was just talking to Floyd. You know, he shows up, Floyd spent the $20 bills, he's talking to Floyd. Floyd's like, yeah, I did it. And Chauvin's like, well, we're going to have to take you in. And then Floyd just drops to the ground, having a fentanyl overdose. And Chauvin just stared at him for 3 minutes. Didn't do anything. And everybody in the crowd's like, help him, give him first aid. And Chauvin's just like, I'll wait on the ambulance. Imagine he just did that. Even if he just did that, he would be guilty of at least negligent homicide and probably third-degree murder. This is so much worse. Whatever else was going on with George Floyd, whatever secondary effects he was having, it is impossible to believe that Chauvin and what Chauvin was doing did not play a role in this happening. And it is certainly impossible to believe that it was reasonable of Chauvin, after George Floyd's heart has stopped and he doesn't have a pulse, not to get off of him and give him CPR, if nothing else. If Chauvin had done that, this case would have been much more difficult. But he didn't do that. And I think the prosecution hammering this at the end about those last 3 minutes really sealed the deal for them. And it was really great of them to point out the one glaring weakness in the defense's case. They could never address this. They could never explain why what Chauvin did at the end of this incident was reasonable.
I will say that these were powerful closing arguments for both sides. You know, that not everyone gets to see trials all the time, and obviously a lot of work went into these arguments. So I encourage all of you not just to take our summaries for it. If you have a chance to go watch them, it's powerful because it is really the culmination of more than a year of work. It's not just the 3 weeks of trial. It's interesting because it's when the attorneys get up and there's theater to it, right? Obviously, there's all the legal and factual basis you're bringing to it, but ultimately, delivery matters here. The jury is your audience and you are a performer. And performer, I don't mean to say that you're acting in any way, but you're a performer because you have to convey your story to the jurors and they need to believe you and you need to convince them. It really is kind of the performance of a lifetime. And it's funny because in law school, it's not like you take any theater classes. I certainly didn't take a public speaking class, but this is so important. If you can't connect with the jurors on these arguments, it's hard to get your point across. And these attorneys, you can tell that their hearts are invested in these cases. You know, a lot of people joke that lawyering is a heartless job, and it's hard not to get invested in your cases. So I encourage you guys to go listen to these arguments because they are of high quality.
I think this whole trial was really an excellent example of our system working at its best. A lot of times when you're talking about true crime, you're looking at trials that are not very good, trials that are disappointing, trials that have prosecution misconduct or defense attorneys who are incompetent or judges who seem like they're trying to railroad the defendant or whatever, you don't see this. And this is, frankly, this is what happens in most courtrooms around the country. Really good advocates doing a really good job for their side and not playing games and not trying to trick people, but explaining why the law and the evidence is on their side. I would be honored to work with these prosecutors. I would be honored to go up against this defense attorney. And I thought the judge did an excellent job. And if you do have time and the inclination, just watching this whole trial, I think, is actually worth it. I think it's a really sort of masterclass in the way this is supposed to go. Now, obviously, it's not over. As you all know, Chauvin was convicted of all 3 counts, and he will be sentenced here in about 8 weeks. And we got a lot of questions, a lot of legal questions about exactly how all this went down. So we'll start with second-degree murder. Those of you who listened to yesterday's episode, I said I thought he would be convicted of third-degree murder and second-degree homicide, but I did not understand how he could be convicted of second-degree murder. After watching the closing arguments and learning some more about Minnesota law, I now understand how he was convicted of second-degree murder. And one reason is because Minnesota law is completely different from basically everywhere else in the country. Minnesota does not have a merger doctrine. Now, we're about to get really nerdy and legal, so brace yourself. But second-degree murder is a really special kind of crime. It's meant to do something which is kind of funny if you think about it. It's meant to encourage people when they commit felonies to do it in a safe way. So if you're going to rob a bank, do it with an unloaded gun. Because if you rob a bank and the gun goes off and you didn't mean it to, but it hits somebody and kills them, then you're going to be charged with second-degree murder because someone died during the commission of your felony. To prevent that from swallowing up all the other lesser offenses, one of the things that you almost never can do is charge someone for second-degree murder for assault, because the elements of assault and the murder would be the same thing. So imagine you're walking down the street, somebody says something about your mom, and you punch them in the face. Well, you've just committed assault. If they die in Minnesota, you've also just committed second-degree murder. That's true almost nowhere else in the country. They call it the merger doctrine. The two merge together, and because the elements are the same, it's assault, but it's not second-degree murder. What you would be charged with is one of the lesser murder charges. Maybe third-degree murder, maybe first-degree manslaughter, maybe second-degree manslaughter, depending on your state or your jurisdiction. But you wouldn't be charged with second-degree murder. Minnesota doesn't have that. So the underlying offense is assault. So essentially, because Chauvin committed an unwanted, unlawful touching on George Floyd and George Floyd died, that meant he was guilty of second-degree murder. Now, here's my question for you, law students or otherwise out there. Come up for me with a situation in which someone kills someone and doesn't assault them. It is difficult for me to come up with an example of that. And vis-a-vis third-degree murder. Obviously, negligent homicide is a little different. You can create a negligent situation in which someone dies. But third-degree murder is going to be difficult. The only one I can think of is if you had like a tiger in your house, like a dangerous animal, and you didn't feed it, and you let it like roam around in your yard, and then it went and ate your neighbor, then I could see, well, it wasn't assault because it was the tiger that did it. It was third-degree murder. But otherwise, usually if you kill someone, no matter how you do it, there's going to be some unwanted, unlawful touching. So I don't really know, other than your wild animal example, which is not what I think Minnesota was going for when they were, codifying these lower levels of murder. So it's a weird state with a weird law, but under the laws of Minnesota, this was a proper verdict.
I just learned a lot about second-degree murder that I didn't know about in Minnesota. Thanks, Brett.
Well, I mean, here's another thing. Think about it this way. And this actually became so apparent when the prosecution was laying out these elements. It is easier to convict someone of second-degree murder than third-degree murder. All you have to show with second-degree murder is an unwanted touching, an unlawful touching that leads to death. If I punch somebody in the face, that's an unlawful, unwanted touching, but it doesn't say anything about my state of mind. I don't have to prove anything about my state of mind other than I meant to do it. It wasn't an accident when I swung my fist. To prove third-degree murder, you got to prove reckless, action. You got to prove a depraved mind. You got to prove that somebody has a reckless disregard for human life. There's actually 5 elements to third-degree murder and only 4 elements to second-degree murder. So it was just funny to see it laid out on the screen where, like I said, it's easier to convict somebody of second-degree murder than third-degree murder.
And this actually goes to what we were talking about in a previous episode, how there's the misconception that a more serious murder is a higher degree. So first-degree murder must be just a really gruesome murder. You hacked someone's head off. But that's not actually what it is. It's the elements that make the murder. And in this case, what you're saying is second-degree murder in Minnesota law, it seems to be easier to prove than third-degree murder, even though logically you may think second-degree murder should be more difficult to prove than third-degree murder. Brett, this actually leads to the number one most common question we got directly after the verdict. We got it through text. We got it through, emails, direct messages. Everyone wanted to know, can you be convicted of 3 counts for 1 crime?
And it seemed like you could, right? I mean, everybody's reported that you could. And the jury, when they gave their verdict, returned a guilty verdict for all 3 counts that Chauvin was tried for. And I'll just tell you, it was funny because people would send us messages and they'd be like, I know this is probably a stupid question, but I don't understand this. And then we would get messages from prosecutors and lawyers and people, everybody asking, like, how is this possible? Because this is another weird thing. Most of us, our experience is you have these lesser included offenses and you're going to be convicted of one of them and that's it. You're not going to be convicted of all the other ones. And I actually said in the last episode, and I cut this out so I didn't sound stupid, that he would be convicted of one of these and not the rest. Well, that's not true. And this is how it works. The jury returned a verdict. The court enters the judgment. And in fact, the judge can do something called a judgment notwithstanding the verdict. So if the judge wanted to, he could hear the verdict from the jury and say, I don't think he's guilty, not guilty, and move on, right? Now, he can't do it the other way. If the jury says he's not guilty, he's not guilty. But what the jury is essentially doing, it's kind of like the Electoral College, right? Like you show up to vote and you vote for Joe Biden, you vote for Donald Trump. Well, you're not actually voting for them. You're voting for electors. And then the electors go and vote for president, not you, right? It's kind of the same thing here. We have all these checks and balances in this country, which can be kind of funny. So the jury is finding facts. And essentially what they said was, we find the facts necessary to prove the elements for all these different charges. When the judgment is entered against Chauvin, he will be convicted of second-degree murder. The other counts will be held in reserve. So imagine a situation in which this goes up to the Minnesota Supreme Court. And the Minnesota Supreme Court says, we were listening to this prosecutor's podcast and it was so good and they really explained why our law on second-degree murder is really dumb, so let's change it. So we're not going to do that anymore. We're going to have merger doctrine. And Chauvin, you're just lucky because you're the person who challenged this. So your second-degree murder charge is vacated, right? Well, that doesn't mean there has to be another trial. What would actually happen is Chauvin would be sent back to the district court, to the trial court. The trial court would vacate that conviction as ordered to do by the appeal court, and then would impose a judgment of guilt on third-degree murder, because the jury's already found that he's guilty of that as well. And they would hold negligent homicide, the second-degree manslaughter, also sort of in abeyance, depending on what happened in the future, and then sentence him on the basis of the third-degree murder. So even though he is quote-unquote convicted of 3 counts, it's not one of those things where he's going to get 40 years for second-degree murder, 20 years for third-degree murder, and 20 years for negligent homicide. That's not going to happen. He's really only convicted of 1 count.
So you see, this just shows you there really are no stupid questions. We had a group of lawyers who were texting each other, prosecutors in fact, and then they couldn't figure it out, so they then texted us. And we were scratching our heads at the same time.
And just in case you wonder, like, how did we know this? Well, I happen to know somebody who used to be a Minnesota Supreme Court justice. So I called that guy and was like, explain this to me. And he explained it to me. So, this was not something that I think anybody really understood, but that's how it works.
And also, we've spoken, if we haven't spoken before, remember there's state court and federal court And the 50 states and the District of Columbia, they each kind of are their own dominions, and they have their own jurisprudence and their own elements for second-degree murder, third-degree murder, first-degree murder, all of these things. So you need an expert in that area of law. We don't practice in Minnesota, so we don't know this off the cuff.
And that's also going to play a role in what the sentence is going to be. So you have probably heard that Chauvin faces 40 years in prison. That's not true. He's not going to get 40 years in prison. And the reason he's not going to get 40 years in prison is because in Minnesota has binding sentencing guidelines.
And real quick, before we get there, Brett, the 40 years you're hearing is the maximum he can that the statute allows for being convicted of second-degree murder. That's where the 40 years comes from. There are usually statutory maximums for different charges, and you may know that second-degree has the highest, and then it goes down for each, with manslaughter being, I believe, just 10 years maximum. And so that's where you're hearing the 40 years come from. The reporters are correct. That's the maximum the statute allows for. However, what Brett's about to tell you about is the sentencing guidelines. There are federal sentencing guidelines, and there are also state sentencing guidelines.
Right. And you may recall, some people have asked, why is it going to take 8 weeks? And if you guys have ever watched The Staircase, you may recall that after Michael Peterson was convicted, he was immediately sentenced right then to life in prison. And his attorney said, they asked if they wanted to delay, and his attorney said, Your Honor, based on the reading of the law, it's a mandatory sentence. There's no reason to delay. And so he gives him life in prison. This is not a mandatory sentence situation. This is a situation in which, as Alice said, there's a 40-year maximum. What his sentence will actually be will be determined by the sentencing guidelines, which will take into account essentially everything about Chauvin, about the crime, about his prior criminal history, about the good things he's done, maybe as an officer, maybe, it can all depend, the bad things he's done, the aspects of this crime that happened here.
By the way, a lot more factors that don't come in during trial. So all of the good acts he did, that didn't come in during trial. Any sort of mitigating evidence, that doesn't come in. But also victim impact, is part of the sentencing phase as well. So we talked a lot about the things that were kept out of trial that were not appropriate for determining guilt or innocence or acquittal. But there are a lot of factors to consider when it comes to sentencing.
And we're about to get super law nerdy, so just brace yourself. You may recall that after the case ended, but before the jury returned a verdict, there was a question about whether or not Chauvin wanted the Blakely factors determined by the jury or the judge. And Chauvin chose to have the judge determine those factors. Now, the Blakely factors come from a case, Blakely versus Washington, I think. Could be making that up, but I think it's Blakely versus Washington. And in that case, the Supreme Court said that any factors other than prior convictions that can increase your sentence have to be determined by the jury. Imagine, for instance, you get charged with trafficking in cocaine. And the jury has to make certain determinations about the amount that you were trafficking in, because the amount can increase your sentence. It's not something where the jury just says, yeah, he's guilty of trafficking, and then the judge says, yeah, and he's guilty of trafficking 40 kilograms or whatever. The jury has to make some factual determinations there to lay the foundation for that. Chauvin chose to have those factors determined by the judge, which is probably pretty smart in this case, because the factors that will be considered are things like there were children who witnessed the death, and Chauvin's position of authority and his abuse of authority. Most likely, the jury, if they're going to find him guilty, are also going to find those aggravating factors. He might get a better shake with the judge, you just don't know. It's kind of a second bite at the apple. So the judge didn't convict him, the jury did. Probably better to see if maybe the judge sees it in a slightly different way. Another thing that's interesting, you all know that guilt is determined beyond a reasonable doubt. Things that you consider at sentencing are decided based on a preponderance of the evidence. So if there is a dispute between the prosecution and the defense, the judge, if he reaches a decision that based on the preponderance of the evidence, Chauvin did X or Chauvin did Y, or this fact is true or not, that's enough. It doesn't have to be beyond a reasonable doubt. Also, those good things and bad things, can come in. And people have asked about this. Will his 17 prior complaints come in? One thing I want to point out about this, maybe not. The fact he has 17 complaints might be really bad, or it might not. Police officers get a lot of complaints. People who get arrested by police officers typically don't like that fact. And some of them make frivolous complaints. Some of them may be legitimate. I think the prosecution will probably take some time to look at those and determine whether or not there's some real substance there, because the prosecution also doesn't want to distract from its strongest hand. And its strongest hand is that Chauvin killed George Floyd, and he did it in this way, which abused his badge, and he did it in front of children. I mean, those are the really powerful things. So I think the prosecution will probably focus on that, and those will be the factors that shape the sentencing guideline. Let's talk about the guideline. There was a movement in the 70s and 80s to make sentencing more scientific and to standardize it and to ensure that if two people who do the same thing with the same criminal history should receive essentially the same sentence.
And essentially what it's trying to do is make it so there was not disparities across the nation, so that if you were convicted of 1 kilo of trafficking 1 kilo of cocaine, you don't get a lighter sentence just because you live in, say, New Jersey versus California versus any other state, so that there would be essentially more fairness across the country, since judges are probably not polling each other on the regular saying, hey, what do you do when someone has, a child abuse case, and how bad of an abuse case? And also to try to fight against any sort of biases against maybe minority communities or anything. It could be based on sex, based on gender, any of these sorts of things. The idea really was to try and reach more fairness, but unintended consequences.
Right. Yeah. The whole idea was we want you to be sentenced based on what you do, not who you are, not who the judge is. You shouldn't be sentenced because you're an African-American person who drew the hanging judge versus, the white guy who drew the lenient judge, like Alice was saying. We want you to be sentenced based on what you do. Well, the problem was, or a lot of people saw this as a problem, you really do want judges to have some leeway. So there used to be federal sentencing guidelines that were binding. Those were actually struck down by the Supreme Court. So the federal sentencing guidelines are just that. They're guidelines. They're advisory. They tell the judge sort of what the general sentence can be, but the judge has a lot of leeway to go up or go down from that. Well, as Alice was saying, the states are different, and there's 50 states, and they have their own constitutions, and they have their own Supreme Courts. And in Minnesota, the sentencing guidelines they have there are still binding. So this guideline range is going to be set based on Chauvin's crime and his criminal history. Obviously, his criminal history is none. He doesn't have one. His crime is second-degree murder, which is pretty serious. Because he has no criminal history, his initial guidelines are going to be about 12 and a half years. If he gets these aggravating circumstances, that bumps that up to about 15 or so. If he gets some mitigating circumstances, it could knock it down to around 10. So you might have a range at the end of the day of between 10 and 15 years. It's not that the judge could not go above that or below that, but he has to find some pretty serious factors in order to do so. And frankly, beyond the ones we just mentioned, I don't know that there are any in the law. So it is probably the case here that Chauvin is facing no more than 15 years in prison and probably no less than about 10 years in prison.
So in other words, the judge really doesn't have as much discretion as some may be reporting that he has.
Right. And so if you're expecting 40 years, change your expectations. It's not going to happen. And don't be upset if it doesn't. In some ways, this is the guidelines working the way they're supposed to. You don't want somebody being sentenced to prison because this is a crime that is particularly political or particularly angry for people or sparks passions. That's sort of the idea. I realize that a lot of people feel like this is a circumstance in which those guidelines don't work. But either way, that is what's going to happen. And then the next step after that will be appeals, which a lot of people have asked about. It's kind of funny. I'm not being critical, but Alice and I have had a lot of conversations with people, talking to Maggie. We were on Maggie Freeling's show on Just Unsolved, and we had a lot of people who wanted to talk to us after that about why is it so hard to appeal, and the doctrine of finality is bad, and we need to get rid of that. We need to make it easier to appeal. And now we've had so many people reach out to us who are terrified that Derek Chauvin's appeal might succeed. And, another reason you need to you got to have a standard, and it applies to everybody, and we're not going to change it depending on the case. Fortunately, in this case, for those of you who feel that way, it is hard to win on appeal. Derek Chauvin has almost no chance of winning on appeal. This case was incredibly well done by the judge, and it is true. There are things that Chauvin wanted to bring in that the judge did not allow him to bring in. And Chauvin wanted to change the venue, and the judge said no. And Chauvin wanted to sequester the jury, and the judge said no. The law is on the side of the judge in all those. So just the fact that Chauvin wanted to do certain things, wanted to bring certain stuff into evidence and didn't get to, does not make his trial unfair. It would only be unfair if those decisions by the judge were unreasonable in of themselves.
And let me say this now, because a lot of people, especially, we had a Get Vocal recently with Maggie and Women in Crime podcast. And here's the thing. A lot of people say, well, wasn't this judge, it's all up to the judge. The judge has so much discretion and so much power on what to let in and what to keep out. Yes and no. Yes, the judge has discretion and makes rulings that those rulings can be appealed. But remember, it is not just an individual person sitting in a robe making decisions based on that individual's gut feelings. Rather, the judge is guided by the rules of evidence, by case law, binding case law, and knowing what the law is, and also the chances of being appealed if they step outside of the bounds that they must abide within. And so, yes, ultimately the judge has to make discretionary judgments, but it is within lanes that have been drawn both by the law and by case law that is dictated by the Minnesota Supreme Court. And so know that it's not just some gut feeling that one person sitting in a robe has. It is one person who has studied the law and has presided over many, many trials and is intimately familiar with the rules of evidence and has vigorous advocates on both sides advocating for their sides, and he makes a judgment based on the law. Oftentimes, when there is an evidentiary argument, which there were multiple throughout the Chauvin trial, when there's an evidentiary hearing, the judge typically goes back with their clerks, with their court staff, and researches the law before he or she makes a ruling to make sure that they are operating and making a ruling that will withstand appeals. And this judge did this in this case. There were no judgments that he made that were obviously outside what precedents required of him.
And I think the one that people have pointed to the most, because of something the judge himself said, was whether or not certain statements by certain politicians could lead to an appeal. So during the end of this trial, there were some politicians who said some things that some people have interpreted as inciting violence if this jury returned the wrong verdict, which obviously, if that were true, would be a threat to the jury and could corrupt the jury and cause us to be an unfair verdict. And I think the way that would probably come in, the defense had asked for this jury to be sequestered. The judge had said there was no reason for it to be sequestered. The defense will appeal, and they will say that was an unreasonable decision by the judge. It was an abuse of his discretion, and they will use this as an example. And the judge recognized that fact when he said, I'm not going to declare a mistrial because the defense asked for a mistrial, but, this might end up getting the whole thing thrown out. I think some of that was the judge sending a message to people, which is, look, yeah, you got a First Amendment right to say whatever you want, but that doesn't mean you should say it. And sometimes you need to be smart about this, and you don't need to try and influence a jury. We have a long history in this country of politicians sticking their foot in their mouth during trials. The Manson case is a famous example of this, when Richard Nixon said, he's obviously guilty and I don't know how he couldn't be, which of course the Manson attorneys were like, well, now he can't get a fair trial anywhere because the president just said he was guilty. So it's something that really irritates judges and should irritate judges. As we said, this was a great trial. This was a jury that was obviously paying a lot of attention, thought about this, spent 8 hours deliberating, went over the evidence, and reached a decision, and it should not be undone because of dumb things that people were doing or saying outside. And for those of you who are concerned, the standard is not just, was this an unfortunate thing that happened, or was this potentially damaging? That will be weighed against the evidence. And the appellate court might say, yeah, they should have been sequestered. And yes, this was a problematic statement that shouldn't have happened. And yes, there's a danger of prejudice. But the evidence in this case was so overwhelming. It was so overwhelming in favor of guilt that I personally will be stunned if any appeal is successful in this case.
Well, we packed a lot of law into an hour, and this has been obviously outside our normal course of going through, older cases, not a current trial. And we appreciate you guys for sticking with us. We hope you've enjoyed it. We hope we've been able to shed some light on the legal process for you so that you can intelligently make your own decisions as you watch the trial, so that you now have, tools in your toolkit for future trials, to understand what sorts of arguments are being made and whether they are proper and what the jury is actually being asked to consider. This is, I think, a civic duty. I think everyone, not just lawyers, should understand these things. All of us can and probably will be called on to serve on a jury at some point. There is a reason that we have written in our Constitution that we have a right to a jury by our peers. It does not say a jury of the elite. It does not say a jury of lawyers or jury of college-educated people. Nothing like that. It is a jury of your peers. So really, it's kind of all of our duties to understand how the justice system works. It affects all of us, not just if you are the one on one side of the V. It affects our society. It affects our way of life and what we decide is appropriate and acceptable within a society. So thank you guys for coming along with us. And, we'll be referring to a lot of what we've discussed in these episodes in all our cold case episodes as well. So this really is just an extension of our typical types of cases, even if it has been, more into the current events.
And I also want to say thank you to all you guys. I have been watching the discussion on the gallery and on our site and on Twitter about this case, and everybody I have seen talking about this and talking about our episodes, it's obvious you guys don't all agree. You come at this from different perspectives. Some of you have family members who are police officers and you're worried about them and you're worried about the environment they're in, and some of you come from communities that are concerned about this kind of violence and what it means for your families. And yet what I saw from people was people talking about this in a passionate but in a respectful way and really kind of hashing this out. And I just thought that was wonderful. And I'm glad that whatever small part we played in facilitating that, I'm glad we could do it. I think we've done a lot of episodes and I've enjoyed a lot of cases, but this was probably one of the most fulfilling things we've done. And I've really enjoyed it. And I hope you've enjoyed it too. I know you guys probably still have questions and comments. Shoot us emails at prosecutorspod@gmail.com, @prosecutorspod on all our social media. Join us on Patreon. Go visit the gallery and talk about this case. You find us wherever you want to find us. We will respond to you. We will answer your questions. We are so thankful for all of you and all of the support that you have given us. This is we're closing in on a year of doing this, and this has been absolutely amazing, and we're really excited about everything we have ahead in the future. Alice, do you have anything else before we sign off?
No, but you all astound us with your intelligent questions and thoughtful discussions. So thank you for being really the best listeners we could possibly ask for.
Well, this has been fun, but next week we will be back to our regularly scheduled programming of Cold Case, Murder, and Mayhem. But until then, I'm Brett.
And I'm Alice.
And we are the Prosecutors. People keep blowing themselves up at gender reveal parties.
Oh no, that happened again?
An explosion at a New Hampshire gender reveal party could be heard across several towns, caused by 80 pounds of tannerite target used for firearms.
Was anyone hurt?
Shook homes for miles.
Oh my goodness.
Police haven't said with the charges. I guess not. That's crazy.
You guess not. Goodness gracious.
Oh man. Just leave it. Just quit. The best way to reveal your kid's gender is just to call your friends and say, yeah, we're having a boy.
It's the safest.
No, I mean, well, I don't know the drugs may be working, but I haven't taken any drugs today. They gave me drugs yesterday, but I don't know. And they didn't know either. You know, the funny thing is they didn't give me a COVID test. Well, the one nurse was like, well, you could have COVID. And I said, well, I just got the vaccine. And she said, well, it doesn't really matter. Like, okay. That's nice.